Hello, everyone. All right, I hope you can hear me. So, welcome back. This is episode number 5. I will introduce myself. My name is Bradley Chaplik. I am a condominium lawyer at Horlick, Levitt, Lella, and this is my third time doing this weekly live stream. Okay, so just to remind everyone, we do this every Wednesday at 12 noon, and we send out emails and reminders to people, but you can also get those reminders automatically if you subscribe to our channel and if you hit the notifications button. So it should be like down there or something like that. So if you do that, then you will, hi. If you do that, then you'll get the videos automatically, and that helps you stay informed and ask us questions and do this this great thing that we do together. So once again, my name is Brad Chaplik. I've been a condominium lawyer for 11 years, and I'm happy to answer your questions today. So I've got a few notes here, and I'm reading your comments over here. So if you see my eyes shifting around, that's what's going on. We're going to talk about some cases. We're going to do the FAQ. We're going to talk about spring maintenance. We're going to talk about electronic meetings and AGMs. And let's jump right into it. Hi, everyone. I see you all in the chat. Thank you so much. Let's get to the first question from Sylvia. So Sylvia's question, our company has heard that the AGM deadline has been extended to 1 year. Can you confirm this, and who authorized this? Oh my goodness. I have not heard this, Sylvia. I cannot confirm it. I'm not saying you're wrong. It just, if it's happened, I haven't heard about it yet. And I saw your question right before we went live, and I went online and I checked the Emergency Management Civil Protection Act regulations. I didn't see anything up there yet. So I'm not aware. I'm not aware that the AGM deadline has been extended to 1 year after the end of your fiscal year. I think it would make sense if they did it, but I haven't seen that it's actually happened yet. So let's hope that that happens. And part 2 of your question, what are the steps to take in holding a virtual AGM? Thank you. Okay, I can answer that. There's 2 steps that you have to take. The Condominium Authority Tribunal talks about this on their website, or not, the Condominium Authority of Ontario, excuse me, talks about this on their website, how to hold a virtual AGM. So let's talk about the 2 steps. First of all, we're going to assume that you do not already have an electronic meetings bylaw. That's a pretty safe assumption. I would say that's going to be true of 99.9% of all condominium corporations. And so the first thing that you're going to do is you're going to pass an electronic meetings bylaw. So that is what's called a low threshold bylaw. That means it doesn't require a vote of the owners of a majority of the units in the corporation. It requires a vote of a majority of the units at a meeting. So I'll explain how that threshold reveals itself. So let's say you have 200 voting units in your condominium corporation. To pass a normal bylaw, you're going to have a majority of owners vote in favor of it. That means at least 101 owners voting in favor of the bylaw if you have 200 voting units. Now let's say you have a low threshold bylaw that you're trying to pass. So first you need quorum for your meeting, which is 25%. So right away, you only need 50 units represented in person or by proxy. In this case, we're going to only do it by proxy. So you have your 50 proxies, and of those 50 proxies, a majority of the meeting, so 26, have to be voting in favor of the bylaw. So whereas in the first example of a regular bylaw, you have 101 units minimum who have to vote in favor. With a low threshold, it's 26 minimum for a condominium corporation with 200 voting units. Big difference. So returning back to your question, first thing we do is we pass an electronic meetings bylaw, which is a low threshold bylaw, and you do that at a paper meeting, a meeting with only proxies. It's a single issue meeting, and you do that in the boardroom with one person present, and you have that paper meeting, you pass that bylaw, you register your electronic meetings bylaw, and then you now you can hold an electronic meeting, and then you would then proceed to hold your AGM electronically. You would use a secure video conferencing software that would allow people to participate fully in the meeting, that would allow the auditor to give the audited financial statement presentation, people would ask questions of the auditor, you would have other business, all of these things would happen. But so 2 steps. First, you pass your bylaw, then you do your electronic meeting using secure software. And the meeting to pass the bylaw is a paper meeting. So this begs the question, well, why don't you just do your AGM as a paper meeting? And the answer is you can't, because of all of those opportunities for the owners to ask questions of the auditor and raise other business, and your election of directors. It's not easily done in a paper meeting. So your AGM has to be a participating meeting, but it can be participating virtually. And that, I think, that seems to be an idea whose time has come. That maybe electronic meetings are something that people are going to become more comfortable with and will become more acceptable as a result of this, state of emergency. Okay, next question. Olivia saying, thank you. Oh, you're very welcome. Hi. Hello to everybody. Next question. Hello, Brad, from Dorina. Interlocking replacement scheduled to start end of April. Engineer's position is cannot proceed as scheduled. Contractor says they can. Could we have your opinion? So yeah, you can have my opinion. I'm giving you my opinion just based on this information that you're giving me. And so this is interlocking stone replacement. Interlocking stone is an interesting example, because a stone that is out of place is a tripping hazard, and you would have the right to re-level a trip hazard on your property, because that's a part of the safety of your property. But you would not have the right under the current state of emergency to do like an aesthetic project. So I would say that the only, giving you my opinion conservatively, the only thing that you could for sure do would be to replace and level any areas that are trip hazards. So I would tend to agree with your engineer that the project should not proceed as scheduled. And you're going to want to look at the wording of your contract, and you're going to want to see what it says about timing of work and delay, if anything, and to make sure that you don't incur any kind of financial penalty for postponing the work. But I think it cannot proceed if it's for design purposes, but for interlocking stone does have a safety aspect to it. So interesting question. Thank you. From LAA, on the meeting requisition form, if we put remove an auditor, do we also have to appoint a new auditor on the same form? I have to take a look at the form. This is a question about requisitions. To remove an auditor without appointing a new one is of no assistance to you. So this is answering the question about removing an auditor. Because the Act says that if you remove an auditor and you don't appoint a new one, then the current auditor continues until a successor is appointed. So as a practical matter, your question about changing the auditor is you always want to be appointing a new one if you're going to not approve or remove the current one. So you should do it. Miriam, hello, Brad. What should the corporation do? Sorry, there's a little funny question there. In regards to noise complaints, breaker tripped in a unit or smell complaint during COVID-19. Can we enter the unit? Okay, so you're saying there's a variety of scenarios where we're getting complaints. Can the corporation enter the unit? Okay, so let's think this through, right? So if someone is complaining and they're asking you to come into their unit to document the complaint. So let's say that it's an odor, right? They're saying it smells like smoke in my unit. We want you to, if you can smell that it smells like smoke without having to go in, then you don't have to go in, right? But they want you to come in and check. So they're given consent. So you can go in with consent, right? There's nothing wrong there. And then so you would maintain a safe distance from people, of course. If your security staff have personal protective equipment, that's even better. They can wear masks. Security staff might refuse to go up to the units, and that's a different issue. But you can go in with consent. So now let's talk about the other side. Can you go in to the unit where is the origin of the noise or the smoke, where they're not giving you consent to go in? And I would say that you probably shouldn't be forcing your way into units ever, and certainly not now. So, but yeah, if someone gives you consent to enter, you can enter, and you can just say, hey, we need to maintain a safe distance here. And that should generally be fine. I hope that answers your question. Oh, okay, so I see the follow-up. What if the superintendent does not want to enter? Well, I think your superintendent might have a good reason not to want to enter if it's not an emergency. And I would say that's fine. If the superintendent should not have to enter a unit if it's not an emergency, and but you'd still have to do your best to document the complaint. That's it. Just do the best you can. Can a person who's suing our condo be nominated for being a director? This is from Rosa. The short answer to your question is yes, unless your bylaws specifically prohibit it. So just repeat the question again, which is, can a person who has a lawsuit against the Condominium Corporation be on the board? Yes, they can. There's nothing in the Condominium Act that says you cannot do that. You would have to disclose it, I think, when you are running. So there's a candidate disclosure form, which says, like, do you have a lawsuit against the corporation, you or any family member? And so you would have to say, yes, you disclose it. And as long as they disclose it and everyone votes for them, then that's fine. Some condos have bylaws which say you cannot be a director if you are adverse in interest to the Condominium Corporation in a legal proceeding. And if your condo has that bylaw, then the answer is no, they cannot. So check your bylaws and make sure that they do the disclosure properly. Now, if they get elected, they would have to recuse themselves from any discussion of their lawsuit. So, but that does happen, and it happens a lot with current directors. So, directors are unit owners too, and sometimes they have legitimate disputes with the Condominium Corporation, and it's nobody's fault. Okay, next question. From Masha. Owners are entitled to access to corporation records with exemptions. Some misinterpret records and discuss on social media, making misinformed statements. Is there any limitation on the number of requests? And then second question, is there any responsibility on the owner side for misrepresentation and public assaults? Okay, this is a really great question, Masha. Thank you so much. Lots to talk about here, so I'm going to try and hit the big points. There are a number of cases in the Condominium Authority Tribunal that touch upon these types of concerns. The concerns that you're talking about are extremely common, and they happen in all condominium corporations. So let's look at an easy one, which is there any limit on the number of requests? So I refer to these as frequent flyers. And the case law from the Condominium Authority Tribunal suggests that someone should not be making multiple requests at the same time for documents that are related to each other. So to give you an example, if someone's really interested in reviewing a contract, and so they ask you to see the contract. While that request is pending to see the contract, they ask you for 8 other documents about the contract. And then while you're still pending on that one, they send you another request form for even more documents. That's considered burdensome. And the idea is that you should wait to receive the first set of documents that you've requested. And then if you still have questions, you can ask for more documents. That's what the tribunal has suggested would be appropriate. Other cases have suggested, someone might make a request once a month, but they shouldn't make requests every day. So there are cases out there that say it's burdensome to receive many requests. I think one had like 42 requests in a period of 18 months. That was considered excessive. So the remedy for the condominium corporation, though, is not that satisfactory, because all you're going to be able to say is that the frequency of the requests is itself a reason why you might be delayed in responding to them. But you would still eventually have to figure it out and get them the records. So just the fact that someone requests records a lot does not disentitle them to receive those records. It might affect the manner in which they receive them. And now let's talk about misinterpreting the information or giving the incorrect information. So this pops up in the cases where condos say, we will give you a record in exchange for a promise from the owner that the owner will not discuss the record with other owners. Or sometimes the condominium corporation will say, we want to promise that you will not copy and distribute the record to other owners. And the tribunal has not touched on the issue of copying, although I suspect I know what they're going to say. But the tribunal has talked about the issue of condos insisting on like a confidentiality, don't discuss the record with other owners. And they've said that there's no basis for a condominium corporation to insist upon that as a condition of giving the record. So you should presume that owners do have the right to talk about the records. But if they do so, they have to talk about them in a manner that is correct, right? They can't talk about the records in a manner that's false or defamatory of the manager or the directors. And so then this touches on your next point, which is there any responsibility not to misinterpret or be abusive towards the manager and the board in public forums? And I would say there's two responsibilities there. So one is defamation, which means disparaging someone's public reputation. And there's all, so that is recognized in law as something that you cannot do. You cannot say things about people that are untrue that tend to lower their public reputation, and you can commence legal proceedings and get civil remedies for people who do that. But then there's a second aspect to it, which is workplace harassment. And so the case law says that using abusive language towards a condominium manager is workplace harassment, and that condominium corporations have a duty to take action to stop it. And there's lots of cases about that. And so I would say that you might approach it not from the defamation perspective, but rather from the workplace harassment perspective. If the unit owner who has requested a record then goes on to social media and makes abusive comments about the manager and, oh, this manager's, a thief or this or that, you would say that this is actually abusive and harassing, and it's intended to, inflict psychological harm upon the manager, which is itself its own type of civil wrong. So I would probably approach it from that perspective and require that they stop for that reason. But all of these concerns about misinterpretation of records is not an excuse not to give a record. And even the people who do this are still entitled to request records and receive them just like any other owner. So hope that answers your question. Long answer to a short question. Kate, if a resident's family has notified property management that a resident has COVID and is in hospital and other residents are in quarantine, what information are we obligated to communicate? Okay, so public health will do something called contact tracing. So you do not have a public health function as a condominium corporation in terms of like trying to track down who this person might have, been in close contact with and all that kind of stuff. I mean, if for the purposes of your own staff, you might want your staff to get tested that they've been in close contact with this person. But it's not your responsibility to start contacting individual residents and saying oh, did you know your neighbor, had COVID? You should get tested. That's not your job. So many condominium lawyers, including me, will say that it's appropriate to put a notice of a general nature in the building saying, we've received information that there's COVID-19 in the condominium community, please take appropriate precautions, and here's what we're doing about it, right? And you would list all of the steps that management's taking to keep the property reasonably safe. You would never identify the person. I know that Toronto Public Health has even suggested in some cases that you shouldn't even post that kind of a general notice because everyone should already be assuming that there's COVID-19 in the community and acting accordingly. So it adds nothing to the discussion. I don't agree with that. I think owners would expect to be informed, at least in a general way, that the management is aware of the problem and that management's on top of it and doing something about it. That's really the purpose of your communication. So I hope that answers your question. So this is another question about requisitions. Can we pre-print a registered owner's name on the signature page of the meeting requisition form and the proxy form? Okay. Okay, so this is a question about, this is a question about how to sign requisitions and how to sign proxies. And so what you're saying is you want to type out the owner's name and then have the owner sign next to their name on the requisition form or on a proxy form. Is there anything wrong with that? I don't think so, as long as the owner, the registered owner, is the person signing it. I don't think there's a problem with pre-typing it. I don't know how much it helps you to do that because I don't know if it's time saving in any way for you. I would suggest the best thing to do is to not do that because you don't want questions about your form being inauthentic or anything like that. You'd prefer just to hand it up and say, look, it's in the handwriting of the owner. It's probably the best thing to do. But I don't think doing it would make it invalid. I think it would sort of needlessly attract scrutiny, and I don't think it makes it any easier for you to do your requisition to pre-type all the stuff. Just let the people sign it. Does that apply to unit owners in a vacant land corporation where they own their own lot? Are they allowed to plant their own flowers? Yeah, people can plant their own flowers because that's not a workplace, right? So Olivia's, can someone on a vacant land condominium in their own property plant their own flowers? And the answer is yes, of course they can. I mean, not of course, it's a good question, but yes, you can, because if it's your freehold property, so take the same example of someone on their own common element balcony or terrace or patio or whatever. Yeah, you can plant your own flowers there because planting your own flowers is not a workplace and you're doing it yourself and there's no restriction on that. So that's totally fine in my personal opinion. Barb, we are a seniors building. Barb, I know exactly which seniors building you are. Can a board restrict visitors into the building and or the number of visitors coming in at one time, whether they are family or not? Okay, so this is a building that is connected to a retirement home. So that's in that sense, it is marketed towards seniors and is considered a seniors building. And so special circumstances apply to you. And I think it would be reasonable in a building such as yours, where you're connected to a retirement home, to have stricter rules for visitors. You would make exceptions for what I would call essential visitors. So people providing care to the people who live in the building, deliveries, all that stuff should still be allowed. With respect to the number of visitors, there's already a emergency order in place restricting social gatherings of more than 5 people. So you could certainly say that your policy is consistent with that emergency order. And then could you be a little more restrictive than that even if you wanted to? Probably. Could you restrict family? I mean, maybe. All of these things are possible. I don't know if they're all desirable. I'm not sure if it will make your common areas substantially safer to do this. But yeah, these are all things that you can think about and come up with a policy that makes sense for your condominium corporation. And in a seniors building, the rules can be stricter. That answers your question in sort of a general way. Okay, let's just find out where we are here in the chat. Lots of questions. Rosa, can DocuSign be used to collect owners' signatures for both requisition meeting and proxy form? Yes, yes, DocuSign. In Canada, we have, or Ontario, we have the Electronic Commerce Act, ECA, I believe, and electronic signatures on documents are valid. So yes, DocuSign or other proper electronic signatures can be used that are verifiable on things like proxy forms. And in fact, companies like Get Quorum use electronic signatures on proxy forms all the time. So there you go. Great question. Ryan, we have similar issues with some patio stone walkways, maybe a potential trip hazard. Contract said it's a 2-person job and can't maintain social distancing. Will be an issue presently. Well, look, if the contractor is not willing to do it, then that's your answer. But if you find a contractor who is willing to do it and fixing your trip hazards, I think you can fix your trip hazards, right? I think that's well within the permitted realm of maintenance for safety purposes, right? Trip hazards, got to be able to do it. So you're allowed under the emergency order. Whether you can find a contractor to do it is another issue. Robert, under the current restrictions for non-essential businesses, including trades, what may be the consequences for the trade company and to the condo for performing the services? You can get a massive fine, is the answer to your question. What's the consequence of having your, not complying with the closure of essential businesses? I think it's like huge fines, like $100,000 or something. Now, you probably wouldn't get a fine that big for first instance, but for example, they could shut you down. And that could be a big problem, right? Let's say you're doing like a garage reno and you start work and you weren't allowed to, and then the municipality finds out and they shut down your work site, and now you don't have a garage and your work isn't getting done, and it's a big problem. So there's financial consequences and there's practical consequences. Mel, we have a company that had guests arrive last night from out of the country. They are here in this building only for their 2-week isolation period. The company said that there is an appeal, in which is why the minimum 28-day short-term rental cannot be enforced. Is this true? We can't enforce it. No, it's not true that you can't enforce it. They're wrong. You can enforce it. So this is a question about the short-term rental bylaw in the city of Toronto. And the answer to your question, Mel, is it is in force, because appealing that decision does not stay the decision. There's a long legal procedural reason for that, but the zoning bylaw is in force, and you, if it's not their principal residence, then it has to be 28 days or longer, and that's the law of the land in the city of Toronto. So enforce. Call your manager, or if you're the manager, call your lawyer and start enforcing. Do it. This is another question about requisitions. Does the owner of several units need to sign for each unit, or one signature required for them all on the signature page of the meeting requisition form? I would get them to sign once for each of the units, because otherwise you might miscount. It's a practical question, practical answer to your legal question, which is if someone owns 3 units, have them do 3 separate lines, one for each unit, so that you don't miscount the number of signatures on your requisition. Otherwise, if you just like think, oh, that person owns 3 units, then you're going to go down the list and you're going to miscount and you're going to make a mistake. So don't do that. Kate, previous question on COVID. We took steps you mentioned, and residents want more info. We don't believe there's anything further can be disclosed. Floor, when diagnosis, in hospital, correct? You are correct, Kate. So Kate's question is, she put up the general notice, just like I said, and then owners want more information, like what floor and when did they diagnosed, and are they in hospital, and can we disclose any of this information? The answer is no, you cannot. You cannot disclose people's personal medical information without the consent of the patient. So if you got consent from the patient and they said, yeah, tell people, I don't care. And if you got that consent in writing, I would say, then you could disclose, but you would need the person's consent. And really, I would just say to the residents who want more information, if you're concerned, contact public health and they'll do contact tracing for you. And that would be how I would deflect that question. Murray, communicating that residents should assume COVID is in the building should meet any other obligation under the Occupiers Liability Act. I agree with you, Murray. I think that yes, management should act as if there is COVID-19 widespread in the community, and residents should act as if COVID-19 is in the community, whether you know about it or not. And the only reason really why management would ever say that they knew of an actual case would be to assure residents that management was aware of what was going on in the building and was on top of it. But it would not impact what you're already doing to keep everyone safe. Okay. Susanna. Hi, Bradley. Great job. Thank you. My question is, if you work for the condo, would you also represent a group of owners of the same condo with a requisition meeting request and following the new board of director election? Okay, Susanna, so this is a question about lawyers and when can we act for different parties. So if I am the lawyer for Condominium Corporation, 1, York Condominium Corporation 1, and I'm their lawyer, and a group of owners approaches me and says, we would like to requisition a meeting of owners at York Condominium Corporation 1. Can you represent us? I would say, no, I cannot, because I am already the lawyer for this condominium corporation. Now, let's say they do their requisition and they are successful and the board is removed and a new board is elected. And that new board consists of the group of people who previously came to my office asking if I would be their lawyer. And I said, no. Can I be their lawyer now that they're the board? And the answer is yes, I remain, unless I'm terminated, which might happen. I would remain as the lawyer for York Condominium Corporation 1, and it would be a new board, but I would have the same client, even though I'm getting instructions from the other group of people. Sort of a funny quirk of condos, but I think I've sort of explained through that example what a lawyer can and cannot do in those circumstances. The other side of it, I'll explain. Let's say I'm not the lawyer for York Condominium Corporation 1. I'm the lawyer for the requisitionists, and I help them with their requisition, and then they are elected to the board. Can I now, as the lawyer of the requisitionists, former lawyer of the requisition, now be the new lawyer for the condominium corporation? And the answer is yes, with the consent of my former client. So there you go. That's a very common situation, happens to condominium lawyers all the time, that we remain as the lawyer when the board changes over, or we go from being lawyers from requisitionists to being lawyers for the corporation. All of these things are very common. All right, where are we now? Betty, my townhouse under condo management, water price raise 100% since February 1, 2020, which is very unreasonable. How can we get help? Oh, Betty, I don't know. Geez. So the water went up. I would have to have a lot more information about this than what could reasonably be figured out in a live stream chat like this. I need to understand why the water price went up 100%, because of course, water rates have not gone up 100%. So that something doesn't make sense there, right? So I think if your water or costs have gone up 100%, you're correctly identifying that there's something unusual going on. And I would like to think that there's a remedy for you, but I'm not sure. I need more info. You can send me an email and we can try and figure it out. I think my email is in the information at the bottom here. You can expand. There's an information thing about this video, and I think my email's in there, but if not, it's bchaplick@hldlawyers.com, and see if we can get you sorted. Include your condominium corporation number in your email, but not any other personal information, and then we'll do a conflict search. All right, is board of directors legally responsible to answer owners' questions via email? No. Rosa. Board of directors is not legally responsible to answer owners' questions via email. There's a case on this. It's called YCC 60 in Brown, and the court said that owners are not entitled to make interrogatories of the board and demand answers to their questions and to demand answers by a specific time and all these kinds of things. Boards often do provide answers to owners' questions, and perhaps they should, and maybe the proper person to answer owners' questions is the property manager, because that's what you hire a property manager for. But no, the board's not legally responsible to answer your emails. Okay, people are so let's talk about a case. I'm going to talk about a case called Noguera. Oh, a question came up. Okay, we'll answer the question, then we'll talk about the case. I want to talk about the Noguera case, really fun case. Bruna, do you know if the city is doing landscaping on their properties or Toronto public housing buildings? I don't. That would be a really interesting thing to know. If the city is doing their own landscaping, like are they planting flowers on Toronto public housing apartment buildings? I don't know. I wish I knew. It's a great question. They shouldn't be, right? Maybe they're not following their own rules. The hypocrisy. I wouldn't be surprised. Okay. Let's talk briefly about Noguera. You heard that they are. That's funny. You might be right. Maybe they are. Probably never occurs to government to follow their own rules, right? Just like all the politicians going off to their cottages. Okay, so Noguera. I want to talk about Noguera. Noguera is a case about oppression and about Section 98 agreements. And so the first thing I'm going to say is I was not the lawyer on this litigation, and I don't know all the facts. I just know what's in the decision. And even from what's in the decision, the facts are really complicated, and I'm not going to talk about everything that happened in the case. I'm only going to talk about the part that I'm most interested in. So what happened with Noguera? Mr. and Mrs. Noguera were on the board, and they owned a unit, and they wanted to purchase the unit next door so that they could join the units, like have an internal door and then make it twice as big. So the unit next door was up for sale, and the person who was selling it was also on the board. And they reached an agreement, and the condo board considered their request for this renovation to join the two units, and it was approved with certain conditions. And one of the conditions was that they could never sell the two units as one in the future. And so they get approval, but they don't sign a Section 98 agreement. And the reason why you might need a Section 98 agreement is because you use these agreements when unit owners alter the common elements, and the wall in between the two units was a common element wall that they were going to put a door through. So they don't do a Section 98 agreement, and the renovation gets underway, and the composition of the board changes, and the new board says we need Section 98 agreements for everyone. And what happens is they say to the Nogueras, you need to sign the Section 98 agreement, and we're going to do the same for everybody else. And for everybody else, they give one kind of Section 98 agreement. And for the Nogueras, they give a different kind because of this condition that the two units could never be sold as one. The board writes up this paragraph, and they add it to the Section 98 agreement, basically saying it might have to be removed in the future. And the Nogueras don't agree to the wording that the board has provided to them. They want to be able to sign the same Section 98 agreement that everyone else got to sign. And the relationship turns really sour between the parties, and the Nogueras bring an oppression application. And there are two important things that come out of this case. So the first important thing that comes out of this case is Mr. Noguera is on the board of directors, and the other directors are holding meetings where they're talking about his renovation. And these are secret meetings, and he's not being told that these meetings are happening. He's not being invited to them, and the court says you can't do this. So what I think should have happened is that the board should have notified Mr. Noguera that they were going to hold a meeting to talk about his renovation in his capacity as a director, but he wouldn't have been able to participate in that meeting. Like, he would have had to recuse himself, not be present in the room. But he still should have known that that meeting was taking place. So lesson number one from Noguera was no secret meetings. And lesson number two was that when you're dealing with an existing renovation or a renovation that was approved but no Section 98 agreement, was entered into, and the Condominium Corporation now wants to bring the thing into compliance, you have to be reasonable, because what the condo said was it's my way or the highway. You have to sign this form of agreement that we've presented to you, and if you don't, we're going to make you take the stuff out, or we're going to rescind our approval, and you're going to have to put your unit back to the way it was. And this would have been oppressive because the Nogueras only bought the unit next door because they had received approval to link them together. And so to say that now we're not going to let you do it anymore, like they bought this property for nothing. So that would have been oppressive, and the Condominium Corporation was not allowed to do that. And the court ordered the parties to enter into a sort of compromise form of agreement. And the Condominium Corporation didn't like that, and they appealed, and they were unsuccessful on appeal. So, and they had to pay depression damages, $10,000 to the Nogueras, and they had to pay costs and the cost of the appeal. So 2 lessons: no secret board meetings, and when you're dealing with renovations that were previously approved or existing, but there's no Section 98 agreement, you have to be reasonable, and you can't take like a heavy-handed approach. So that's the Noguera case, and that's a 2020 decision from the Ontario Court of Appeal. I just thought I would tell you all about that. Something has nothing to do with COVID, but just because we're doing condo law, right? Okay, great. Let's go back to some more questions, and then we've been going for about 40 minutes, so we might call it a day pretty soon. So let's do a few more questions. We'll wrap up. This is LAA. What kind of documents required or should be submitted to the management with the meeting requisition form? What kind of document? Okay, so a requisition is its own document, right? This is, so you request a meeting of owners, and it's signed by the owners of at least 15% of the units. And on the requisition, it should state what the purpose of the meeting is. And I think that's it. That's all you need to submit. Now, doing a requisition now during a state of emergency is not a great idea, because it might be that the Condominium Corporation cannot hold the meeting. So you want to think about your timing. But yeah, requisitions. There's a whole section on the Condominium Authority of Ontario website about requisitions, and they have templates. And I would just say grab the template off the Condominium Authority website and read their guidelines, and you should be all set. All right, Rosa, if the condo lawyer doesn't show empty voting box to owners, even she was asked to, then can we do anything against this procedure? Like, okay, so Rosa's asking about the election of directors and whether there was a miscount. So there's a couple things you can do if you think that there was a miscount on your election of directors. The first thing you can do is you can ask to see the ballots and proxies. You should make that request in a timely manner after the meeting. You should also object during the meeting. I don't know if that advice is of much use to you now, but you would object during the meeting. You would ask to see the ballots and proxies or a copy of them in the form of a request for records. You would be able to do your own recount with those records, and then you would be able to satisfy yourself that the result was correct. And if in the course of your recount you determined that the outcome was not correct, then you would usually ask the person who was wrongly elected to resign, and you would see the person who was should have been elected, they would take their place. That's the simplest way to do it. And if they refuse to resign, you might have to go to court. So that's how you correct it. It's not that fun. Alex Martin, what can you do about a board member that is constantly questioning the property manager and sending emails to the property manager every day and also calls him every day? I can tell you what you can do about that. So what you would do is you would pass a board resolution, and the board resolution would say who on the board is entitled to contact or communicate with the property manager in the capacity of a director outside of board meetings. So let's say that you only want the president of the board to be able to give instructions to the property manager outside of board meetings. So you pass a board resolution and saying only the president has the authority to give instructions to the manager outside of board meetings. Everyone else, you're just a regular unit owner outside of your board meetings, which would be true in any event. And so then when the director is, sending emails to the property manager, those emails are received just as they would be received by from any other unit owner, and the property manager would respond to that director in the same way that the property manager responds to every other unit owner, which is, professionally and with great courtesy, but not necessarily just doing what the person said because they've said to do it. So I think that should give you some direction, Alex, on what to do about your constantly questioning director. Very common situation. Robert Buckler, what condominium corporation number was the Noguera case? Muskoka Condominium Corporation 22. Maybe after this video, I can do something right now. I'll type it in. Noguera v. MCC 22. There you go. Noguera v. Muskoka Condominium Corporation 22. There you go, Robert. Rosa, what possible drawbacks can we expect provided the majority of votes and proxies are completed correctly? I don't know what you mean. This is about the election where you weren't happy with the election counting, and you're saying what drawbacks can we expect provided the majority of votes and proxies were completed correctly? So, like, you mean you asked for a recount and then it turned out that the count was correct? Oh, I don't think there should be any negative consequence to you for asking for a recount. It's your right as an owner. There should be no reprisals for people who request for records and want to double count things. It's totally fine. Murray Johnson, a board liaison policy should be in place to define the scope of authority for that directors outside of a board meeting. I agree, Murray. Thank you. Murray and I agree about a lot of things. So yes, a board liaison policy is what I've described in my answer. What kind of information should be on ballots? On the ballots, this is Rosa's question about elections. What kind of information should be on ballots? What should be on ballots is the, let's say it's a ballot for an election of directors. It should be the name of the director who the person is voting for, and that is it. You would not put the unit own, like you don't sign a ballot. If that's your question, ballots are anonymous. Adib, can board change titles midway through the year by vote, and what is the best way to do it? So the officer positions you're talking about. The board. So typically when you appoint officers, you appoint them for a year, but you can change them anytime. So if someone wants to step down as the president and you're going to elect a new president from among the directors, you can do that. They should just, you should indicate that that's what you want to do in advance of your meeting, put it on the agenda of your board meeting, and then pass resolutions appointing new officers. That's totally fine. Do it. You might have to send out a information certificate update if you do that, though. I have to check. Information certificate update. If you change officers, I'm not sure. If you change the board, you have to send it, but I'm not sure if the same directors changing their officer positions. I have to check. LAA, if on the notice of meeting stated that proxy is not valid without appointing an auditor and proxy is sent to owners without that section, will proxy be valid? On the notice of meeting, it said that proxy is not valid without appointing an auditor. I don't agree with that. I don't agree with what's on the notice of meeting. I think that's wrong. I think it's wrong. I think you can sign a proxy without appointing an auditor. So you would want to raise that at the meeting. I think the information on that notice of meeting is not correct. So let me just I'll just reiterate this question. So the question is, there's something in the meeting package that says that a proxy has to fill out certain information, and if it's not filled out, then the proxy will be invalid. And the requirement to appoint a auditor is not one of the statutory requirements of a proxy. So they've attempted to create their own rule, and I think that you can't do that. I think the form of proxy, the mandatory form of proxy, is what it is on the Condominium Authority of Ontario website, and condominium corporations don't have the right to change it and make their own rules for proxies. It's mandated by statute. Okay, we'll do one more question here from Rosa and then see if anything else pops up immediately, and if not, we'll call it. Rosa, are ballots legal without a serial number? Yes. Yes, you don't have to have a serial number on ballots. I mean, it's great if they have those types of things to make sure that people aren't stuffing the ballot box. But there's other ways that you can make sure that the ballot box isn't being stuffed. For example, you would check the number of ballots with the number of units represented in person, and they should be approximately the same number. So if you had 30 units represented in person and you had 100 ballots, then that's a problem. But if the numbers matched, then that's probably going to be okay. But no, there's no obligation to put a serial number. There's no statutory form of a ballot. Proxies are very regulated, but the ballots are not. So I think that's everything, guys. We talked about electronic meetings. We talked about spring maintenance. We talked about the FAQ. We talked about Noguera. I told you all to subscribe. So that's my FAQ. That's my AMA live stream. Ask Me Anything. Please come back and join us again next Wednesday at noon. Thank you, everyone, for all your questions. It was great. One more question here. What can I do if management enters my unit without giving any notice? They need to give you notice under Section 19 of the Condominium Act, reasonable notice, and unless it's an emergency. So if there's like an active water leak or something, they might be able to enter without notice. But what can you do? You would tell them not to do that, and you're going to want to have a discussion with your condominium corporation and make sure that you get notice. Section 19 of the Condo Act, you have a right to notice of entry. Thanks, everyone. All right. Thank you again. And keep your eye out for next Monday. We'll update the FAQ, send it out by email every week. And we just keep adding information as more and more questions pop up and more new things happen. And I will, at the very first question at the beginning, someone asked me about whether the deadline for condominium corporations AGMs had been extended. I was not aware of it, and I will check. And if they are, it'll absolutely be in the next FAQ. Thanks, everyone. Bye.